Can the government force a property owner to accept Section 8 tenants? That's not just a policy question, it may actually be a constitutional one. In this video, we're breaking down California's Section 8 law and why it may conflict with your Fourth Amendment rights. In California, a law known as SB 329 makes it illegal for landlords to refuse a tenant based on their source of income. That includes Section 8 housing vouchers. So in practice, landlords can no longer choose whether or not to participate in the Section 8 program. It's effectively mandatory. And that's where the issue starts. Section 8 has always been a voluntary program, but participation comes with strings attached: government inspections, ongoing compliance requirements, and administrative oversight. Now the question becomes, if participation is no longer optional, are landlords being forced to give up constitutional protections? The Fourth Amendment protects against unreasonable searches. And this is where a key Supreme Court case comes in. In Camara v. Municipal Court in 1967, the court ruled that housing inspections conducted by the government are considered searches under the Fourth Amendment. More importantly, the court held that these inspections generally require consent or a warrant. In other words, the government cannot just enter private property for inspections without proper legal process. Now apply that to Section 8, and even local programs like Sacramento's Rental Housing Inspection Program. Both require periodic government inspections of rental properties. But here's the key issue. If landlords are forced to accept Section 8 tenants, they are also being forced to accept government inspections as a condition of renting their own property. So the argument is this: the government cannot do indirectly what it cannot do directly. It cannot bypass the warrant requirement by conditioning your ability to rent your property on agreeing to inspections. That's where serious constitutional concerns arise. We're already seeing courts start to take these arguments seriously. In a recent New York appellate case out of Ithaca, a local law that required landlords to accept Section 8 vouchers was struck down. This wasn't just a trial court, it was reviewed by a mid-level appeals court, and the decision was unanimous. The court found that the law effectively forced property owners to participate in a government program that required inspections of their property. And because those inspections are considered searches under Camara, the court held that this raised serious constitutional issues. As a result, that requirement is no longer being enforced in that jurisdiction. Now, it's important to understand, this decision only applies in New York and does not override California law. But it does show that courts are willing to push back when government mandates go too far. For now, California law is still in effect, and landlords are required to comply. But this is an evolving legal landscape, and challenges like these could reshape how far the government can go in regulating private rental housing. At the end of the day, this is about more than Section 8. It's about protecting fundamental property rights. If you own rental property in the Sacramento area and have questions about programs like Section 8, feel free to reach out anytime. We're here to help you stay compliant and protect your investment.